then going over to page 260, items 285, agreements in which Elliott Stoker was a party were those sold to Franciscan Alliance.
They're similarly listed.
If we go back to page 2, in the beginning of the agreement, the next item is D, under paragraph 1.1. What items does that indicate were sold?
Reading from the document, it says, all permits, licenses, certificates, and governmental authorizations, approvals, and related certifications to the extent assignable, which are held or used by the seller and relate to the ownership, development, and business operation of the purchased assets or the practice.
Okay. And item number E, does that indicate that all prepaid expenses were sold to Franciscan Alliance?
Excluding those set forth in Schedule 1.2, I believe so.
Your Honor, may I ask, does Your Honor have a copy of this agreement in front of you?
Can we go like that? The schedule's on it.
May I approach, Your Honor?
Yes.
Thank you. Continuing on, Doctor, to the next item. States that deposits made by seller under equipment leases and practice sites leases included among assumed contracts. Those deposits were sold to Franciscan Alliance, were they not?
That's listed, so
Is that a yes?
I believe so.
Item G states records, which includes all books, records, files, and other documents, whether in tangible or intangible form, used in or relating in any way to the operation of the practice or the purchased assets, collectively records, including without limitation all medical and patient records, patient consent or authorization forms, promotional materials, financial records, patient lists, and employment records subject to seller's post-closing right of access as provided in Section 9.5 below. Were those records sold?
I believe so.
Same for the intangible assets listed under item H, which is the intangible assets of the practice, including without limitation, patient lists and patient medical records or charts, relationships with referring physicians, the trained and assembled workforce of the practice, going concern value, all trade names and marks used in the practice, including without limitation, those set forth in Schedule 1.1H, intellectual property of the practice, telephone numbers, operational know-how, the institutional, personal, and professional goodwill associated with the practice, and a restricted covenant. Those items sold to Franciscan.
Well, I believe that it's largely true, but I think that the workforce was leased to Franciscan and ultimately to be acquired. But that's an understanding, an agreement that was verbal, that was shared between the parties.
Doctor, my understanding is part and parcel to the agreement, and I'm going to ask you this whether I'm wrong or right in my assertion. FCCI, which was one of the selling parties here, FCCI LLC, would lease its workforce, which were administrative people, nurses, non-medical professional personnel, to Franciscan Alliance until at least December 31st, 2012, whereupon they would become Franciscan Alliance employees. Is that correct?
I don't think the date was certain, but the concept of the lease was agreed upon verbally.
Do you know why that was different? Was it the logistical problem with insurance and payroll, taxes, things like that, that made that a logistical problem to transfer those people immediately? you had to wait till the end of the calendar and fiscal year?
It was a request from the Franciscan Alliance to me, and I didn't go into asking for a lot of detail. They would have their own reasons, and I had no reason to object.
Doctor, the next let me hand you what I've marked as Plaintiff's Exhibit number 1. I ask you if you can identify that document.
It's the employee lease agreement between Family Care Center and Franciscan Alliance.
Okay. And what's the date of this agreement?
The effective date is October 1st.
Okay. And what was the, to remind the court, what was the effective date of the asset purchase agreement?
I believe October 1st.
Okay, so these agreements were done simultaneously, and this agreement contains some of what I just described, which was the agreement that FCCI would lease its employees to Franciscan Alliance until perhaps December 31st, 2012. Is that correct?
I can't tell you the date this was signed. My signature page is not dated, so I don't know the date that I agreed. The conversation had been ongoing. The effective date goes back to October 1st, but I can't tell you when the document was produced and when the document was signed.
So when you stated earlier that this was a verbal agreement, this wasn't more or less in writing, was it not?
Ultimately.
But you don't know the date on which this was signed.
As I say here now, I don't.
And we move to admit Plaintiff's Exhibit number 1.
Yeah. Sorry, number 1's admitted.
Move on, Doctor, on page number 3 of the asset purchase agreement, Keyman Life Insurance, called Keyman Policies. On yourself and Dr. Stokar, were those sold to Franciscan?
Yes.
Dr. Stokar and yourself, if you know, considered Keyman within the Franciscan organization?
No, I think I was considered the key man, and they wanted life insurance on me, and I said that FCCI had that these policies that previously acquired, they'd sold the $10 million that Franciscan wanted on me. They were willing to accept that in lieu of the policy on me. So I think that I was considered the key man.
Okay. Dr. Stokar's policy was also purchased?
Yes.
Meaningful use payments in item J, those are payments that that medical specialists would have been receiving from Medicare and Medicaid, and those were going to be transferred to Franciscan Alliance after October 1st?
Yes.
Okay. Paragraph K appears like a catch-all, states other assets. Other than the excluded assets is defined below. All other assets and interest, real, personal, or mixed, tangible or intangible, owned and used by seller in connection with the operation of the practice, and all other rights to own and operate the practice. Those other assets, not specifically excluded, were sold to Franciscan. Is that correct?
I think that paragraph speaks for itself. It's legalese, so I would defer to counsel.
Dr. Stummer, after the asset sale and on, call it the morning of October 1st, 2012, what assets remained the property of medical specialists in D.C.?
It certainly had its name. It held contracts that it had an obligation to fulfill, so it had obligations with various hospitals to fulfill duties. had the contracts of all the non-signing, the physicians who elected not to sign on with Franciscan Alliance, so it remained a company employing over 7 doctors, I believe.
Doctor, you remember giving a deposition in this case on August 13th, 2013?
Yes.
I was present at that deposition, as was yourself and Mr. Jensen.
Yes.
Do you remember me asking you the following question, you giving the following answer on page 15, beginning at line 17, David? Okay, so if October 1st was, let's call it the trigger date, when assets were sold to Franciscan Alliance, what assets of Medical Specialists Inc. PC were not sold? Answer: the accounts receivable that were due. There's approximately $1.5 million in Keyman life insurance policies. So there's cash assets. So there's cash assets that weren't sold. I don't think the name was sold. I mean, obviously they did not buy the stock of the company. So the company exists as Medical Specialists Inc. PC. You remember me asking that question and giving that answer?
Yes.
Doctor, could you turn to page number 32 of the asset purchase agreement? Starting at section 9.4, on the bottom of page 32, there's a provision that is entitled Restrictive Covenant Protecting Goodwill. Do you see that?
Yes.
Basically, does it state that the seller, except on behalf of the buyer, will not compete with Franciscan Alliance for a period of 5 years within a radius of 25 miles from 757 45th Street in Western Indiana. Is that correct?
I think the document speaks for itself.
Is that your reading of the document, or do you think it says something else?
Yeah, I think that it basically says that we're agreeing not to compete. We can cooperate, but we're not competing.
At some point in time then, Doctor, was that agreement not to compete partially waived by Franciscan?
I believe you're referencing the May 22nd.
Correct.
Yeah, I believe it memorializes the areas that I view as cooperative, that are clarified as non-competitive.
In other words, it would be Franciscan Alliance and Medical Specialists working in concert to achieve a common goal.
Well, Medical Specialists had a goal which was, I would call a win-win. It was a win for Medical Specialists and a win for Franciscan, and so it was a mutually beneficial agreement.
May 22nd agreement, Doctor, I think you have it up there as Exhibit T.
Sure, I think I got some.
Yeah. You have Exhibit T there, Doctor?
I do.
Is that the May 22nd agreement you just referred to?
Yes.
Correct me if I'm wrong, Doctor, but May 22nd is about 8.5 months after October 1st, 2012. Is that correct?
Approximately.
Doctor, if I were to submit to you that your response to our motion for summary judgment was due May 24th, 2015, and you disagree,
I'd have no way of knowing that date. I had no basis for disagreement.
do you know, Doctor, in your mind, or from your experience in dealing with this agreement, is that the May 22nd date and the May 24th date being so close, is that purely coincidence?
I can't speak to it. This was a discussion had been ongoing for many, many months.
Who prepared this agreement, do you know?
No, I don't.
Who gave it to you, do you know?
It was placed on my desk. I don't know.
Who has access to your office to place things on your desk?
The executive staff of the organization.
I don't want to know what you said, but did you speak to any attorneys regarding this agreement?
Only in the sense that I knew it had been finally agreed to.
Did you assist in any way in preparing this agreement?
No, I did not.
This agreement, in the bottom paragraph on the first page, bottom whereas paragraph, does that paragraph contemplate that a lawsuit had been filed or state that a lawsuit had been filed by the departing physicians against medical specialists?
I think the agreement has to speak for itself. It's legal terminology, and I will decline to comment on the intent of that paragraph.
Does it say the following words? Whereas each of the departing physicians declined to accept employment with Franciscan and has filed a lawsuit claiming, among other things, that despite the fact that medical specialists invested significant funds in developing their practices, supported them financially while they developed their practices, and introduced them to patients and patient referral sources, their respective restrictive covenants contained in the employment agreements with medical specialists are no longer enforceable. Does it say those words?
Those words are there.
So was it any part of the purpose of this agreement to defeat this lawsuit and entering into it Franciscan Alliance?
I don't know that I can speak to the intent of the attorney who drafted it. I think I'm not the right person to ask that question.
On the second page 8 of the agreement, I already said it's signed in counterpart. That is your signature, is not.
Page 8?
Page 8. There are two page 8s. One has Mr. Leahy's signature. The other appears to have yours. I'm asking you if that is your signature.
That's fine.
If you turn back, I want you to try to keep both documents in front of you. I know it will be easy because the asset purchase agreement is large. The asset purchase agreement that's there in green, the paragraph 1.4 sub small a sub double I on page 7. Deals with non-consenting providers. Do you see that paragraph?
Yes, I do.
And it talks about, in general terms, how non-consenting providers will be dealt with. Is that correct?
Could you repeat that question, please?
Sure. Paragraph 1.4 sub a sub small double I talks about non-consenting providers and generally states how in this transaction non-consenting providers will be dealt with. Is that correct?
I would read it differently. I think it agrees with what the seller will do to kind of deal with those concerns. I don't know that it is how you deal with non-consenting providers. This obligates the seller.
It does say that the seller shall reasonably cooperate with buyer. Is that correct?
Yeah, I think we're saying the same thing.
So to cooperate with the buyer must also do something, or else you're cooperating with someone who's laying there like a post. Is that about right?
Do you think that question makes sense?
Sure.
I don't.
If someone says, I need you to cooperate with me, you can't really cooperate unilaterally, can you?
I would say that it does take two people to agree. One person cannot agree without a second person agreeing.
And who would be defined, well, let's deal with who's sitting in this courtroom. Who here would be considered a non-consenting provider, if anyone?
Who's present in this courtroom?
Yes.
I think your four clients, Drs. Lois, Satasi, Sethi, and Patel.
So this provision in the contract then, amongst perhaps others, is one that would deal with handling those positions. Is that correct?
I guess I'll object to the form of that question. Phrase the question.
When this paragraph talks about non-consenting providers, at least four of the people it talks about are Drs. Leo, Sethi, Atasi, and Patel. Is that correct?
Those four names would be, I think, included under the general category of non-consenting providers.
Okay. And then if you go back to Exhibit T, which I think is that there right underneath, on page number 2, makes specific reference in the third whereas paragraph of section 1.4a, then it has a number 2 as opposed to a double I. Is that correct?
The third paragraph, which begins whereas section 1.4 parentheses A parentheses 2?
Correct.
I see that.
Is it your understanding that what that paragraph is talking about when you look back at the asset purchase agreement is 1.4a, it's sub-double I, which sometimes is referred to as 2, but I don't know if you understand that that's dealing with the same paragraph or not.
If you're saying, can I accept that double I is the same as 2, I can accept the likelihood of that?
Okay. Would you also accept that in the asset purchase agreement there is no 1.4a to number 2?
There's 300 pages here, and it's not on this page. I don't know if it's on another page.
There's only one section of 1.4. I know it's tedious, but I need it for the clarity of the record in this case.
I have no reason to believe that the number is repeated somewhere else in the many hundreds of pages.
In that paragraph we just referenced in Exhibit T, which is the May 22nd agreement, it does in fact state that medical specialists will reasonably cooperate with Franciscan, as Franciscan may reasonably request, in an effort to obtain for Franciscan the benefits of each non-consenting provider's employment agreement with medical specialists after closing. Does it say those words?
Yes, it does.
So did Franciscan make a request to medical specialists that medical specialists and Franciscan agree to waive the non-compete 25-mile radius for medical specialists?
Are you saying, does it say that in that paragraph?
Does it say that in this agreement? Is that your understanding of what Franciscan and medical specialists agree to?
I conducted the conversation verbally, and this is reduced by attorneys to writing. So the conversation was that medical specialists, there was a vital and shared interest by both organizations for medical specialists to agree to provide services, to hire and employ doctors, to provide care to patients, and fulfill its obligations to hospitals. And attorneys attorneys crafted the language that both parties could agree, medical specialist attorneys and Franciscan Alliance attorneys captured that intent.
From October 1st, 2012 until May 22nd, 2013, this agreement did not exist. Do you agree?
I mean, the document did not exist?
Okay, the document did not exist.
If it did, I haven't seen it. The agreement to cooperate existed.
Doctor, if a physician who was formerly employed by medical specialists did not agree to assign his contract to Franciscan, do you believe that Franciscan would have a right to enforce the contract as far as the restrictive covenants are concerned against that decision?
I guess I'll object to that question. That's a legal conclusion on whether or not this position believes that the contract is enforceable by Franciscan Alliance. I don't know that that's been established that he has sufficient expertise to reach that conclusion.
Fair enough. If you could turn, Doctor, to page number 3. It begins to talk about the waivers of the restrictive covenants. Is it your understanding that this agreement provides that medical specialists can employ up to 5 full-time equivalent physicians?
It says that.
And how many physicians and other medical professionals did medical specialists employ prior to October 1st, 2012?
Prior to October 1st, 2012, medical specialists employed approximately 60 physicians and 15 nurse practitioners or physician assistants.
And this agreement, I think you already answered this agreement allows for 5 specifically or 5 full-time equivalent specifically.
I think that's fundamentally correct.
Did medical specialists pay money to Franciscan Alliance to be allowed to compete in what was previously the non-compete zone of 25 miles?
Could you repeat that?
Did medical specialists pay Franciscan any money or anything not to compete, to waive the non-compete provision within the 25-mile radius of your main office?
So you mean, was there a price for this agreement?
Correct.
No.
The document also states in paragraph 4 on page 3 that medical specialists would recruit and hire these replacement physicians. Did you do the recruiting and hiring of those physicians?
Yes.
Do you also do that for Franciscan medical specialists as president of that organization?
Yes.
Why would not you simply recruit those doctors into Franciscan if they were needed to replace doctors who left medical specialists?
For the reasons I have explained to you a couple of times. Northwest Indiana has hospital systems that view themselves as significant competitors. Those competing systems would prefer to deal with doctors who are employed by a physician-owned organization and not be referring, have their doctors refer to employees of a competing organization and not have contracts which are paid to a competing organization. organization. And so to continue the opportunity to work peacefully and to create a better environment for future cooperation, medical specialist needs to employ those physicians, and Franciscan Alliance agreed.
And those physicians or doctors do not Stokar, Weaver, and Dr. Daniel Smith, is that correct?
They include those doctors.
Any others?
Well, Dr. Rademacher and Dr. Cucrasia are anticipated as well.
Are Dr. Rademacher and Cucrasia medical directors of any hospitals?
No, they're not.
So, as far as medical directorships are concerned, that, as you stated, would create a concern for competing hospitals. Why is it necessary that Dr. Rademacher, let's start with Dr. Rademacher, be an employee of medical specialist in PC?
The founders of medical specialists, the partners, agree that allergy and immunology is an integral part of pulmonary services as relates to asthma, for example, and allergic lung disease, immunodeficiency syndromes, which are treated by both the infectious disease doctors and the pulmonary doctors. And the partners wanted to include that specialty.
But not as a medical directorship.
Not at the current time.
So, if the idea, and if I'm missing something, please tell me. If the idea is to protect relationships with the hospitals, with doctors who are medical directors, why is it, to your understanding, that medical specialists in PC has to have recruited new physicians who would then be in the role of clinicians as opposed to medical directors? Clinicians don't work for the hospitals.
Medical specialists, owners, shareholders, had a vested stake in protecting and continuing to provide care to pulmonary patients, and they viewed allergy and immunology as a part of that spectrum of care. And so it was on behalf of medical specialists that specialty was included.
Okay, tell me why Dr. Cucrasia?
Medical specialists' partners had a very significant financial investment in a dermatology office space, which is leased, and they have a vested interest in this ongoing success of that office space. And so they were also very committed to the continued delivery of dermatology services.
Did medical specialists and all the other entities who were sellers in the asset purchase agreement sell that clinic to Franciscan Alliance?
They didn't sell the leasehold improvements of the building, and so they continue to have a big investment in those leasehold improvements and in the building.
And if you do the recruiting for Franciscan Alliance as well, at least for Franciscan medical specialists, tell me why it is that the doctors have to operate under the name medical specialist in PC, specifically Dr. Cucrasia. Okay? Why does Dr. Cucrasia have to operate under that moniker as opposed to just Franciscan Alliance or Franciscan medical specialist?
That was the decision and the election of the shareholders of medical specialists.
Doctor, is it also an attempt on behalf of medical specialists to create a interest in operating an independent medical practice that could be protected against the covenant not to compete?
That could be a benefit of that same decision.
You spoke a little bit earlier, Doctor, about efforts that were made in regard to the four plaintiffs here in getting their practices started in Northwest Indiana. You should try to recall those. That you've gone around the community and introduced the doctors and done things to advertise their services to get them some business, book of patients. Is that correct?
Those are your words. They're not my words, but I understand your concept.
You helped them get started. Is that your words? Does that help?
Yes, we recruited them, sponsored them for their privileges, introduced them to many physicians, advertised for them, provided them space, provided them education, provided them patients, provided them a living, provided them a salary, provided them benefits. We did all that. Medical specialists did all that.
Did you do all that for the charitable purpose of enriching those doctors, or was it also to enrich medical specialists?
Medical corporations are typically formed by medical physicians to support and enhance their own careers. And so you need doctors for call coverage, you need doctors for vacation coverage, you need doctors to provide services and to expand the spectrum of services that were available in our community. So there are many reasons to recruit doctors. But I would say, well, there are many reasons to recruit doctors and to grow a medical enterprise.
Is one of those reasons so that the enterprise can make money?
The enterprise has to make money to stay afloat, but there are many reasons. One of them, one always targets profitability as a reason, and of course, targeting unprofitability is a pathway to failure. So one would always endeavor to keep every decision, to make every decision so it could have a profitable outcome.
I guess what I'm getting at, Doctor, is the effort and time spent assisting the doctors to get up and running was not just for their benefit, but also for the benefit of the organization, which you were president of and the largest shareholder in.
Well, I'm not the largest shareholder.
I'm sorry, you're tied.
Apologies accepted. So would you repeat your question or your statement?
What I'm trying to get at, Doctor, is the work that the organization did, or that you did individually, to help these doctors get their practices started, was not only for their benefit, but it was also for the benefit of the organization, medical specialists in the DC.
There are multiple benefits. So to put it into perspective, if you're an infectious disease doctor, you can't work alone because you're on call 7 nights a week, every week of the month, every month of the year. And in that way, you cannot provide coverage to patients. So you need to bring in associates so that Saturday and Sunday and Rosh Hashanah and Yom Kippur can be covered when you are not available to do that. And so, yes, you do that to provide patient coverage, you do it so that you can maintain a lifestyle, you do it so that you can survive, you do it so that you can hopefully be productive throughout your entire career and have a long and healthy one.
Regardless of which way, did the organization, medical specialists in DC, up until at least October 1st, 2012, benefit from the employment of the 4 plaintiffs here?
Certainly.
In talking about benefits, what was the sales price of medical specialists in DC and other southern entities paid by Francisco?
The combined sales price?
Correct.
Approximately $21 million.
Doctor, as part of that $21 million sale price, there was a part, if you can recall, without me having to go to a specific page, of the asset purchase agreement that required the consent to assignment of their employment agreements for 48 physicians working for medical specialists in DC. Do you recall that provision?
Yes.
How was the number 48 physicians arrived at?
It was offered by counsel for Franciscan Alliance. I think he offered 49 and I suggested 48.
So for the $21 million sale price to be effective, 48 physicians essentially had to consent to assignment of their contracts in total to Franciscan Alliance.
Could you restate that?
In order for the $21 million purchase price to be paid, these 48 physicians had to sign assignments, consents that their employment contracts would be with Franciscan Alliance as opposed to medical specialists in order for the sale to close.
That was one of the terms of the agreement.
And were those 48 of the physicians signed?
I believe so.
And those 48 of approximately how many?
I think perhaps 58. It might have been 57. I'm not sure of the exact number. Oh, let's say between 55 and 60.
Doctor, would you agree with me or would you disagree that in obtaining at least 48 physicians to sign their consents, that Franciscan received the benefit of its bargain in the sale and purchase of the assets?
Would you please say that again?
Given the fact that at least 48 physicians signed their employment contracts to Franciscan, would you agree with me that Franciscan received the benefit that they bargained for in the asset purchase agreement?
I do not.
Do you agree that in obtaining the 48 doctors' signatures on their assignments and consents to be employed by Franciscan, that you received the benefit that you bargained for in the asset purchase agreement, the $21 million?
I do not.
Do you think you should have been paid more?
No, it's not an issue of being paid more.
Do you think Franciscan should have paid less?
No.
Do you think Franciscan should have paid more?
No.
Try to clear this up. Do you have Exhibit B there, Doctor?
Yes.
Doctor, could you please, in this agreement, I think you testified previously that of all the medical directorship agreements, that this one contains some provision within it for a provision of actual clinical care as opposed to administrative services. Do you recall that?
I think I may have referenced that.
Okay. The doctor's duties, or the medical director's duties, under this particular medical directorship agreement, I think you will find at Exhibit A, which is after the signature page, page 14.
Yes.
There are 24 duties listed there. Do any of those duties state that the medical director will physically treat patients in the hospital?
That sentence doesn't exist there.
Does any sentence exist here that calls for the doctor to perform clinical services as opposed to administrative services?
The doctor has to maintain his license to practice medicine. He has to maintain his board certification. He has to have effective working relationships. Serve as a role model.
Any of those
Interact courteously and compassionately with patients, families, significant others, and associates. And it includes scheduled clinic time.
Which paragraph did you just reference? I'm sorry.
Page 16, item 17, second bullet.
Item 17 on page 6. Is that correct?
Page 16, the final item is 17. 17 has 6 bullets.
You're looking at a different agreement.
Yeah, I'm sorry, Doctor. You're looking at a different agreement than I'm looking at. It should be Exhibit B.
I'm looking at B.
And is that on the face of it, Doctor, is it March 1, dated March 1, 2013?
Stated medical director agreement, January 1st, 2013, between Munster Medical Research Foundation and medical specialists, and it talks about a Department of Wound Care.
May I approach one step?
Yes.
To see what the difference is.
We have the record reflecting that the document is Exhibit F, and the witness's attention is being directed to Exhibit A, which has 24 bullet points.
So that one that says. So I'm now looking at something that's marked F.
Okay.
Apparently I did not receive an F. Which is not true throughout my entire life, but here I did not get it.
As opposed to an F.
I'm going to have to probably... Well, let's put it this way. As far as that contract as a medical directorship dealing with wound care, I'm going to try to make this a little easier, Doc, because I think I have 2 different agreements still. That would require a doctor to have some clinic hours. Who is that medical director?
I don't know what contract you're talking about now.
Well, who is F? The contract that you have marked as Exhibit F. Whom is that between? Who are the parties?
This would be for Dr. Weaver between St. Mary Medical Center and medical specialists.
And what is the date on the face of it? Is it March 1, 2013?
March 1, 2013.
And that states that it concerns the practice in the field of wound care and ostomy services. Is that correct?
Ostomy.
Ostomy. I'm sorry. Ostomy sounds more like astrology. It's probably not right.
Pardon?
Wound care and ostomy services. Can you describe what those are in the report?
Can I describe what wound care services are?
And what is ostomy? What is ostomy?
Ostomy?
Ostomy.
In today's world of complex disease, many patients develop defects in their skin surfaces, which the layperson would call, and I think the professionals would call, wounds. These may be wounds on the feet of diabetic patients who have lost feeling. It may be wounds elsewhere on the body as related to surgery, which may have gotten complicated. It can be wounds from autoimmune diseases, self-allergic conditions that destroy blood vessels. It could be wounds from circulatory conditions such as atherosclerosis. It can be wounds from unusual fungal and parasitic and bacterial organisms that simply destroy skin and underlying tissues. And the doctor must be able to diagnose those conditions appropriately through all the modalities available and implement a comprehensive treatment plan, which is not only medication, but also includes local therapies, including the cleaning of the wound, which is called debridement. It's cutting away and scraping away dead tissues, crusts, and debris that accumulate in wounds, and applying local medications, and applying the appropriate dressings, prescribing the appropriate offloading devices such as splints or casts or crutches, and giving the patient advice and making sure that they are educated on this and have the necessary home equipment and sometimes home services to manage those wounds so they have their best chance of healing. Ostomy services are related to some of the similar problems that relate to people who have had diversions of their colon or their urinary tract tubes, urostomies or colostomies, and some of the problems that develop with the management of those. That is that's the far smaller part of this contract.
Okay. And then what would a physician have to be specially trained in or be a specialist in to be able to be a director, a medical director of these services within a hospital?
There's not one line of training that leads to the qualification to be such a medical director. There are different pathways that physicians can elect or select in order to reach this goal. So obviously in Dr. Weaver's case, it's the broad training in internal medicine to understand all of these diseases, the broad training in infectious diseases to understand all of the infections and the complications of infections, and then specific attention to education through conferences and through reading to learn all the techniques that are available and obviously putting these into practice and developing experience, and then developing a team of people to help deliver these necessary services.
Do you know, Doctor, if any of the four plaintiffs in this case are as particularly qualified as Dr. Weaver, who's listed here to cover those services under this medical director agreement?
Well, I believe that Dr. Otassi has some skills in this area.
Has Dr. Otassi ever been the medical director at St. Mary Medical Center in Coburn for infectious disease or for wound care?
Not as far as I know. He certainly would have covered those patients on rounds or evenings, weekend rounds or evening rounds, so he could have been covering those clinical care responsibilities for those patients.
These are the same. I think they're both F. Okay, so let's make sure one of them's one.
Doctor, did you specifically recruit a Dr. Suyin Chi?
Pardon me?
Did you specifically recruit a Dr. Suyin Chi?
I specifically hired a Dr. Suyin Chi as a result of recruitment efforts.
Did you undertake to do those recruitment efforts yourself, or did someone else do it?
I make the request or give the direction, and then other people institute certain other pathways that result in applicants submitting curriculum vitaes. Then I review the curriculum vitaes and make a selection as to whom we make arrangements to transport in. Then other people make those arrangements. Then I conduct the original interviews, the initial and final interviews.
As far as Dr. Chi is concerned, when did you first speak to Dr. Chi, if you can recall?
I don't have the date.
Do you remember interviewing Dr. Chi in person?
Yes.
Do you remember approximately when that was?
I don't know the date.
Do you think it was before June 30th, 2012?
Yes, it was.
I'm sorry, before June 30th, 2013.
I'm glad you corrected yourself. Yes, it was before June 30th, 2013.
Do you know if it was before May 30th of 2013?
I don't recall. I think it was, but I'm not sure.
Doctor, until May 22nd of 2013, pursuant to the terms of the May 22nd agreement, would you have been permitted, pursuant to the terms of the non-compete in the asset purchase agreement, to in any way hire Dr. Suyanchi? I'm sorry, for medical specialist increase.
Could you repeat that, please?
Sure. Prior to the May 22nd, 2013 agreement, would you have been permitted, pursuant to the terms of the non-compete in the asset purchase agreement, to hire Dr. Suyanchi to in any way be employed by medical specialist Inc. PC as a physician?
I believe I likely would have been permitted.
Is there anything in writing that would give you that permission to do that?
No.
Doctor, I think you have the contract or the employment agreement with Dr. Suyanchi in front of you. Exhibit L.
I have Exhibit L.
Doctor, what date is written on that agreement? At least let's say on page 1 on the top.
June 6th.
Is that the date that you signed the agreement, or the date that Dr. Chun signed the agreement, or both, or neither?
I can't say that I can pick any of those choices. It could be any of them. More likely neither.
Who would have wrote June 6th in there, do you know?
Possibly a staff member before filing.
Does the court have a copy of Exhibit L?
Thank you.
So, Doctor, do you think that before the agreement was sent from your offices to Dr. Chi for signature, whether it had your signature on it or not, did it have the date June 6th on it?
I wouldn't know.
When does Dr. Chi's employment with Medical Specialists Inc. begin?
She's hired now, and I believe that her first date of service is expected to be October 1st.
Has she, to the date, as we sit here, received a paycheck from Medical Specialists?
She may have gotten a signing bonus. I can't recall. It's possible that she's gotten a signing bonus. She would not have. She won't receive a check for services until the end of October or the beginning of November. Actually, she won't receive a check. She'll receive a direct deposit.
Okay. Do you know if this agreement calls for a signing bonus or whether Dr. Chi received a signing bonus?
Most of the physicians do receive a signing bonus, but I can't recall in this case.
Does she currently have benefits provided by Medical Specialists Inc. PC? Health care, for example?
I don't know.
Is she currently licensed to practice medicine in the state of Indiana?
I don't know.
Is she currently licensed to practice medicine in any state, in any capacity?
I don't know.
approximately how long was your in-person meeting with Dr. Chi?
My initial meeting?
Yes.
Probably 90 minutes.
And you had 2 meetings with her that day, I understand. How long was the second?
Shorter.
How much shorter?
I don't recall.
Was it less than a half hour?
I don't recall.
At any time during the interview process with Dr. Chi, did you inform Dr. Chi that medical specialist Inc. PC had, back on October 1st of 2012, sold substantially all of its medically related assets?
I don't mean to smile, but I don't think a doctor would use those words. If you ask the question differently, I might have. I don't want to simply say, no, I would not have used those words, but if you want to ask the question differently, I'll try to.
Did you tell her medical specialist sold its assets to Franciscan Alliance?
I wouldn't have used those words either.
What would you have said?
I would have said that we have joined with the Franciscan Alliance and are going forward with them. And then I would have described the opportunity to stay with medical specialists. That an opportunity exists within medical specialists to provide services and the reason to do so.
Did you inform Dr. Chi that medical specialists of May 22nd agreement with Franciscan Alliance, which is cancelable on 90 days notice, did you let Dr. Chi know that Francisca could cancel that non-compete and that she could be out of work on 90 days notice?
I'll check the form of the question.
I would not have discussed.
The doctor,
Oh, excuse me.
I think the doctor understands
I've
it.
got 2 questions.
I'll rephrase it. Did you inform Dr. Chi of the agreement dated May 22nd or any of its terms regarding the waiver of the non-compete between Franciscan Alliance and Medical Specialists Inc. PC?
So you're asking if I informed Dr. Chi about the May 22nd agreement.
Correct.
I don't think I would have referenced the May 22nd agreement.
Did you tell her in any respect, in any way, that on 90 days notice, medical specialists would not be allowed to compete with Franciscan Alliance?
As I said, I don't think I referenced that agreement in any way.
I didn't ask you about the agreement. I asked you if you informed her that on 90 days notice, Franciscan Alliance could cancel, or I'm sorry, could invoke a non-compete against medical specialists.
I didn't reference that subject.
Do you know, as you sit here today, what Dr. Chi would do if, in fact, Franciscan invoked a 90-day cancellation provision?
I don't know what Dr. Chi would do.
It's possible that she wouldn't have anywhere to work within a 25-mile radius of your main office. Is that correct?
I don't know that that's possible. I don't know that's likely. I don't think that. I think we're talking about hypotheticals, and I would prefer not to get involved in something that's just fanciful.
Do you suppose, knowing the consequences of those actions, would be fanciful to Dr. Chi?
Please ask that again.
Doctor, do you think that Dr. Chi should have been informed of these things? That her employment that hasn't even, or services that haven't even started yet are in jeopardy or never started?
I guess I'll object to the question now on the basis of relevancy.
Well, Your Honor, it's relevant because, for one, Dr. Chi has been made to enter into an employment agreement, which we're trying to use to say, yes, we're employing clinical physicians, so you can't compete with us. And Dr. Chi's employment could be canceled on 90 days' notice, at which point we're not competing with her. We're medical specialists in that arena.
I'll rule the objection. You can answer that.
In the event that the non-compete was canceled, medical specialists would still have an obligation to pay Dr. Chi for 2 years. She'd receive her paycheck.
Doctor, aren't doctors' paychecks calculated on performance, that is past performance, to some degree?
Doctors are guaranteed a base wage, a base compensation package, and that compensation package includes incentives when they exceed certain targets. And so the incentive is over the base guarantee, but they're always guaranteed a base.
Doctor, where does Dr. Chi live currently? You know,
I don't know.
does she live in this area, Northwest Indiana, Chicago?
I don't know.
Is it contemplated by medical specialists that Dr. Chi will be a clinical practicing physician or a medical director?
She may be both.
In her current contract, where she will start performing duties on October 1st, 2013, is it contemplated therein that she will be a medical director?
We always contemplate that doctor career trajectories will be rising, and that a directorship is something that people aspire toward, and it requires, of course, that opportunity to become available. And so I would say that it would be a reasonable expectation of both medical specialists and Dr. Chi that that could very well occur in her career.
I'm going to move to strike that as non-responsive. I asked anywhere in the agreement, does it contemplate her being a medical director? Or is this agreement for provision of clinical services on behalf of medical specialists in PC?
It says in her contract on page, no, it's not, it's the Exhibit A. Provide such other services that are reasonably requested by medical specialists and agreed to by the physician. And on the final page, it says, included in net receipts are all payments received on behalf of physician for director's compensation from hospital, nursing home, or other entities. So it is contemplated that that could very well occur, and we always hope that it does.
Okay. Doctor, do you know, is Dr. Chi basically just finished her fellowship after completing medical school?
Dr. Chi is completing her fellowship after completing her residency, after completing her internship, after completing medical school.
Has Dr. Chi, to your knowledge, been in private practice before?
I don't know.
Doctor, I'm going to hand you what I marked for identification as Plaintiff's Exhibit 2. Do you recognize that document, Doctor?
It's entitled Affirmation of Alexander A. Stemmer, MD.
Doctor, I'll submit to you that this document was submitted along with the designation of evidence in your response to the plaintiff's motion for summary judgment. Does that ring a bell to you?
Yes.
Okay. Could you please turn to page number 10, paragraph number 26.
Yes.
Towards the bottom of paragraph 26, it states, and you have signed this document, medical specialist is the employer of Dr. Chi.
Yes.
This affidavit was submitted with which we've agreed to summary judgment response motion that was filed on May 24th of 2013. Dr. Chi's employment agreement is dated June 6th, 2013. Do you agree?
That's the date that's on the document.
Dr. I'll hand you what I marked as Plaintiff's Exhibit 3 for identification. Sorry, I moved to admit Plaintiff's Exhibit 2.
Exhibit 2 is admitted. Yeah, why don't we take a break?
What is number 3, please? I'm sorry, the affirmation of Alexander Stemmer submitted with the petition for preliminary injunction.
And let's take a short, obviously he's got a lot more to cover with this witness, so this would be a good time to take a short recess for lunch. Convene back at 1:30.
Very good.
All right.